afternoon, ladies and gentlemen. I would like to invite all of our guests to be seated as our book and series, author series, will begin right now. So my name is Mohammed Masua. I'm currently an MSc student at my 4th semester here at INCEIF. On behalf of the organization committee, and I would like to welcome every one of you to our book and author series. Thank you for joining us for today's session. So just a little reminder before we begin, please turn off or set your hand phone to silent mode through all this event. I appreciate your collaboration, obviously. Thank you. Ladies and gentlemen, as an introduction, the INCEIF Knowledge Management Center, in collaboration with our alumni office, is to organize the 5th book and series. The first series of this was conducted last February in 2021, featuring our INCEIF alumni, Dr. Haji Mohd, who shared about his book, Beyond FinTech, Technology Applications for the Islamic Economy. For today's session, we are happy that our INCEIF alumni, Dr. Syed Adam Alhabshi, has accepted our invitation to share about his this book that he wrote with Professor Dr. Abbas Mirakhor, Adjunct Professor Dato Setia Dr. Haji Mohd, Haji Mokhtar, and Professor Datuk Dr. Syed Othman Alhabshi, on titled Shariah Investment Agreement, the legal tool for risk sharing in Islamic Finance. Before I invite our speaker, let me share with you quickly our speaker background. So Dr. Adam Alhabshi is currently a partner at Raja Darli and Law and head of the Islamic Finance Practice Group. He holds a PhD in Islamic Finance from the International Center for Islamic Finance from 2016. He also holds a Chartered Islamic Finance Professional from INCEIF also in 2010, and the law at the International Islamic University of Malaysia in 2006. Dr. Syed Adam is currently the Honorary Secretary and a Grand Council member of the Chartered Institute of Islamic Finance. Professionally, he also qualified as the Chartered Professional in Islamic Finance, CPIF. Dr. Adam is also the internal auditor and an associate member of the Association of Shariah Advisors in Islamic Finance, Malaysia. He currently sits on the Islamic Finance Committee of Bar Council Malaysia as the co-chairperson. Without further delay, let's give a warm welcome to our speaker, Dr. Syed Adam Alhabshi, to share on his book, Shariah Investment Agreement, the legal tool for risk sharing in Islamic finance. Doctor, the floor is yours.
Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi wa barik wa sallim. Thank you very much to the MC. Thank you to INCEIF for inviting me on this book and author series. Before I begin, I think I'd like to invite everyone to recite Surah Al-Fatiha for Sheikh Sheikh Yusuf Kadawi. Right. Thank you for joining me. Together with me is one of the co-authors, my father, who is with us. Thanks, Jal also. Thanks for supporting the event. I think what I plan to say and share, probably Jal knows the subject matter better than I do. Right, the reason why I'm in the cast is because I broke my collarbone while playing football last Friday night. they said it's because I'm old and everything. I said age is just a number, and the problem is that lawyers are never good with numbers. So on that note, I'd like to put a caveat that, or disclaimer, that I'm on painkillers right now. So if I do say anything that doesn't seem to be proper or anything, I will blame it on the painkillers. Well, what I intend to talk about with regards to this book is actually a bit of a background to the book itself. I think the content of the book, you can all read it. You can read it if you have the book. I've asked INCEIF, and they said that they had the soft copy version of the book. On that note, I'd like to present one book to INCEIF so that you can have it in the KMC. The whole idea of the book is actually, it's a small jigsaw piece of the bigger picture of risk sharing, as what Prof. Abbas had intended to make it possible in Islamic finance. So that there's this idea of this Prof. Abbas and risk sharing, which he himself said that if you were to hit him and if he was to bleed, then you won't see blood, but you probably see risk sharing coming out of his body. So this is just a small jigsaw piece to that big risk sharing puzzle, and that particular piece is actually to cover the legal and regulatory framework of risk sharing in order for it to be practiced in Islamic finance, right? So that's the whole idea of the book. It's done. It's a book that is being converted from a PhD thesis. So when I was writing the PhD thesis, I had the idea and the intention to make it into a book, and that was one of the reasons why I chose a qualitative thesis rather than a quantitative thesis, so that it will be easier to convert the thesis to be a book after graduating. And I think that turned quite well. In other words, it was quite easy to convert the book to become to convert the thesis to be a book. And the book itself, the whole idea is to cover three main components, right? The first component is with regards to the concept of al-bay' from the Shariah perspective. The second is to address the position of common law and the applicability of al-bay'. And the third is to prepare like a product or a template agreement which can facilitate this risk sharing product if we were to adopt it. Of course, back in 2016, when it was drafted, it's still at its infancy stage. I think as we develop the law, etc., right now, if you were to prepare the whole agreement, there would be some need to tweak the template agreement that was already prepared in the book. Particularly after being under job for about 4 years, I think when I saw the template agreement, and I said, I think there's much more that can be improved in the template than what before it can be launched into the market, right? So then the whole idea is that I wanted to showcase how the common law is actually congruent with the Sharia. As a background, the intention of the book had always been in order to please Allah subhanahu wa ta'ala, and firstly, and secondly is to allow people to be comfortable with using risk sharing product in Islamic finance, to show how the contract is actually fine under the common law if we were to adopt this Islamic this risk sharing kind of product in the market. So what happened in the book was that I started with a problem statement, which is to showcase how risk sharing can be developed into a product. It's like the thesis itself was like when you buy an iPhone, right? You want it to be able to plug and play. You buy the phone and you can immediately use it and use it to make calls and everything. The moment it's out of the package, you can immediately use it. That's what I did for the thesis, which I think was quite a good strategy as well. The second strategy, if you're a PhD student as well, to share with you. Are there any PhD students? Or masters, is it? Alright. So if you're intending to do PhD, one of my strategy was that, number one, I chose a subject that is about Islamic finance, but it's about law as well. So you don't have that much lawyers in the faculty, so you don't get that much questions during your preparation of the product itself. If I were to do it at UIA, I think it would have been scrutinized even more. But doing it at INCEIF, I think I got lucky there. So that was a good strategy. And the second good strategy is to select a very good examiner, good supervisor. So you have, for me, I got Prof. Abbas and Dr. Haji Naim. Dr. Haji Naim is the Chief Justice of Shariah Court in Malaysia. So having his name there gave comfort to people or when they wanted to criticize the product itself. So that's two strategies that I think is good. But I was very lucky as well because I had a de facto supervisor at home who was very adamant about me completing my PhD fast. You see, I wanted to graduate when he was still the chief academic officer. And then in 2016, early 2016, he told me he did not want to renew his contract the following year, which meant that I had to finish my thesis in that year, or else if I complete the thesis the following year, he won't be on stage when I receive my scroll. So that sort of like pushed me to complete my thesis in 2016, which Alhamdulillah managed to complete I completed the draft in, as I calculated, it was 3 months, 20 days. The whole PhD thesis. Whilst working at MIDF at that time, I was lucky to get the flexible hours. So got in at 10, left at 7, went back home, had dinner, went to sleep, 4 o'clock, wake up, right until 9 o'clock every day. And then weekends it was 6 to 6. And Alhamdulillah, I have very strong support from my wife as well, who is here, who is also holding the position of my PA and nurse at this moment, taking care of me and getting me dressed while I'm being an OKU at the moment. So she took care of the kids and I took care of the thesis. So as a de facto supervisor, Prof. Syed Othman actually went through my manuscripts and commented, and that was the scariest part, I think, because his comments were quite very sharp and straightforward. So it was a bit of a tough position because we're staying together. I'm staying with him. So every day he would be asking, what's the update, what's the progress. So if you have a supervisor at the university, then if you don't go and see them, then they might not be asking you about the progress. If you're staying with a de facto supervisor who sees you every single day and asks you about the status update, then you get a bit stuck if you don't write anything. So that was, I think, one of the good reasons why I completed the thesis in 3 months and 20 days. Then it took about a few months for the supervisors to check and then sent it out to the external. Dr. Naim was the external supervisor because there wasn't. I think there wasn't any legal candidate for the thesis, so I got a special approval for an external supervisor to be the one of my internal supervisor. So all that went by quite fast, and the thesis was completed fast. It's also because in the preparation for the thesis, the proposal stage, that took me about 10 months, because that's the time when I had already collected all the data, all the articles, and all the necessary references needed for the thesis. So the moment it was approved, it was a get-go, and then it's just about writing, right? So at that stage, I had already formulated an idea with the help of the supervisors, especially Prof. Abbas. But I still remember how he and my father cornered me to do the PhD at my dad invited him for dinner at home, and invited me, and living in the same house, so I was invited to the dinner as well. But after the dinner, they cornered me at the car and forced me to accept forced me to give my word that I would register for the PhD, and because of that, I couldn't back down from that, and I still remember Prof. Abbas saying, "Don't worry, I will prepare all the work for you, and it's just about passing the exams." Well, it did not seem to be that way lah. That was just his promise. But he did give the whole idea of his understanding of risk sharing, which I think you can get from his books, from his articles, and from other students who he had supervised. The concept of risk sharing, right? So coming back to the book, from the Sharia perspective, what I did was I tried to show a few points from the Sharia perspective with regards to al-bay'. Definition of al-bay' itself, right? I distinguished it with tijara. Why I distinguish it with tijara is because the book suggested that most of the Islamic finance product that we have in the market are debt-based. And debt-based means you needed a contract to establish the debt obligation and the liquidity. So you have the debt obligation and you have the liquidity. It will mirror to a loan agreement, which also gives liquidity and debt obligation to the borrowers. But for Islamic finance, in order to generate that debt obligation and liquidity, you needed a few contracts to establish that. You can't combine the contracts into one because it's riba. Money cannot be used as a commodity. So you can't rent out money, you can't use money as a commodity. Therefore, you needed to have a different type of contracts in order to establish the debt obligation, and another contract to establish the liquidity. Hence, what we would have seen in the market right now is the commodity murabaha product, where it creates the debt obligation and the liquidity, but it doesn't use the property that it intends to finance as the underlying asset, right? So you have this debt obligation, this debt-based product, which I still recall and mentioned in the book, that when you draft or when you structure a debt-based product, there is a need to remind the Sharia Committee that this is just a Panadol to solve the current problem of the bank having a product. It is not the antibiotic to the economy, which is very at a very high level of having debt-based product for financial products. In fact, in the BNM 2022-2026 blueprint, there is a small mention which I think is critical, where BNM has said that there is over-reliance on commodity murabaha at this moment, which as you can see, some banks are actually trying to develop other type of products to move away from this commodity murabaha product, right? That in itself is an indication that what kind of other products should the banks be focused with. It can't be another debt-based product, because it will just increase the debt problem of the economy. Hence, the reason why there is a need to at least play around or to start having a risk-sharing product. So, in the second chapter, the first chapter is on the introduction, where it was in the book we discussed a little bit about the common law conflict, the Shariah Investment Agreement template, a practical alternative, and then developing the template and validation of risk sharing in Islamic finance. In the second chapter is about Sharia, defining al-bay' and how it can be applied. So instead, there are theses, I think by Dr. Saad Bakali with regards to the Sharia aspect of risk sharing. I think that details, that goes into a very more Sharia detail of how al-bay' is different from tijara. And in my thesis, I just applied just a little bit about that, whereby the al-bay' is distinguished from tijara in the sense that tijara is considered as trade contracts, which what we have in the debt-based product, and al-bay' is defined as investment. So one of the points in the book is that the distinguishing factors between al-bay' and tijara from the Quranic perspective, because there are verses in the Quran where al-bay' is used to distinguish it from riba. وَحَلَّ اللَّهُ الْبَيْعَ وَحَرَّمَ الرِّبَا. And there are verses in the Quran where al-bay' and tijara is used in the same ayah, which means that it should not refer to the same having the same meaning, or else the Quran's efficiency of using Arabic language would be in question. Therefore, it must mean two different things. And there are verses in the Quran where al-bay' was used in the beginning, like Surah Al-Jumu'ah, وَذَرُوا الْبَيْعَ, and then later on at the end of the verse it says, go and do your tijara after the prayers. So there is a distinguishing factor between al-bay' and tijara. So I adopted that approach to distinguish between al-bay' and tijara. And then another point in the second chapter that I wanted to share is with regards to Sharia and fiqh, whereby, as we see, most of our products now is always regarded as Sharia compliant. Everything is Sharia compliant, or if there's an issue, then it becomes SNC, Sharia non-compliant. So there's a small chapter that I distinguish between Sharia and fiqh. In a nutshell, is that Sharia is the immutable laws of Allah. It cannot change. That's the hukum of Allah. Allah says it. If it's A, it's A. That's it, finished. No need to question anything, right? But there are areas where you need to have fiqh scholars to try and understand what is the meaning of the hukum that Allah intended in the Quran. Therefore, fiqh is an understanding of the scholar, and this understanding is subject to mistakes, because as you know the hadith, if you make an ijtihad, proper ijtihad, and if you're wrong, you get one reward, but if you're right, you get two rewards. So in that context, fiqh is always fallible. You can make a mistake with fiqh, but Sharia is immutable. It cannot be wrong, can never be wrong. So there's a sub topic there on the oversimplification of using terminologies of Sharia compliant, because there are cases where the court ruled that the product is not Sharia compliant. So how can it be that a product is Sharia compliant, meaning it's consistent with what Allah wants, and then at the same time later on someone else can say that the product is not Sharia compliant. So that's the dilemma between Sharia and fiqh. I think there was also one chapter which discusses about property rights, where it starts with about being a mu'min, the different level of human development, where at the last stage is that you need to become a mu'min, and the mu'min is like a tuning fork of a piano, whereby a true mu'min is supposed to be able to you are always able to rely on a mu'min to determine the right behavior. So it's like a tuning fork, right? So when you're doing your piano, if you need to tune the piano in the olden days, now you can use gadgets, but in the olden days you use a tuning fork, whereby when you hit the note and then you play the note, then you try to make the note match. So that tuning fork becomes like a benchmark for all the Muslims, for all the mu'mins. And in that, there's a particular chapter that talks about that mu'min are supposed to be a tuning fork to other mu'mins. And then there's also a particular point on property rights, where it was discussed that in determining a product to be a property to be a valid property, then what you need to look at is whether the product can be used for something that is Sharia not compliant or not, right? And that the book lists out 4 criteria or 4 benchmark for determining how you spend your property or your wealth. One is to avoid israf, excessiveness. The other is to avoid itlaf, and then to avoid itraf. One is opulence and the other one is destruction. And the last one is to avoid tabdil. And in the Malay language, everything that we do, if it is considered as excessive, we always call it as mumbazir, right? But in the Arabic word, the tabdil is only meant for things which are really Sharia non-compliant. The things, how we use the word bazir in Malay is an oversimplification of the word, of that word itself. For example, if you go for Ramadan bazaar and you buy 5 curry puffs for you to break a fast, when you know that you can only eat probably 2, right? If you don't finish your curry puff, people will say you mumbazir. But that's not mumbazir. That's in Arabic. That's supposed to be israf, excessiveness, right? And there's different levels that Allah doesn't like those who are israf. But then when you do things which are mumbazir, the true meaning of mumbazir, which is to use your wealth for things which are definitely Sharia non-compliant, like buying alcohol or going to a prostitute, for example, then these are the terminologies that falls under the category of badil or tabzir, and you are compared to ikhwanu shayateen, the brothers of shaitan. So that is also explained in some parts of the book. Alright, so those are the Sharia aspect, the buy and tijara. There's a table of the distinguishing factors between al-bay' and tijara, and some discussion on musharaka and its elements. When it comes to the common law, I think Tun Zaki mentioned to me before, and then later on I found a case law that supports his contention that the common law must be common sense. If it doesn't make sense, it's not common law. And I think throughout my training with JAL, I think that is also the same approach, where whenever I presented a legal opinion to him for clearance, the way that he would check is to use common sense and test out the principles and to stretch it and to flip it to see if it makes sense or not. So common law is all about common sense, and it's all about efficiency in business transaction, right? So there's also subtopic where it's discussed about, and this is what I always use with pupils when I do interviews, is to ask them that if you are allowed to, in a contract, if the breach of the contract doesn't hurt the person, then there is an incentive to breach the contract. And the common question is that if you buy a nasi lemak if you sell nasi lemak for RM1 and then someone comes to you and orders 50 nasi lemak, so that's RM50, and then another person comes to you and wants to buy your nasi lemak for RM100, so that's 5,000 ringgit for is it 5,000? 550 times 100, yeah, 5,000. Told you lawyers are not good with numbers. So 5,000 ringgit. So, and you can only make 50 nasi lemak in a day. So, but the person who came with the 100 ringgit per nasi, who's willing to pay that much, came later. So, what's the position? What's the legal position? So we get the pupils to think about breach of contract, about reputational risk, etc. So that's one of the economic factors in relation to breaching of contracts, and that's discussed also in the book in one of its subtopics. And then there's elements of partnership and under common law. The situation where it was discussed where common law actually is an offspring of the Sharia. So if you look at throughout the book, Sharia is always mentioned as the first. The second comes the common law. I think this one Saleh can confirm with me that our teacher Habib Umar is always adamant that when we want to discuss about the Sharia, we cannot simply do a comparison with common law because it's not of the same level. The Sharia is the law of Allah. It is always a higher level. The common law is man-made law. So in that context, if you look in the book, all the mention of between Sharia and common law, Sharia is mentioned first, and the distinguishing factor between Sharia and common law, Sharia being Allah's immutable laws, and common law being man-made law, is distinguished, and the differences are shown in a respectable manner to Sharia itself, right? And then sorry, I thought my co-author wanted to say something. And then the other interesting point is that when I was doing the thesis, Prof. Abbas mentioned one particular article by Professor Makdisi in the US. I've never heard of him before, and I couldn't get his article. So what I did was I wrote to him, I wrote an email to him, and he sent me his article, and he also sent me some of the journals where there was a comparative law seminar done in the US back in 1980s. So he sent me the materials, and that actually helped me to establish the position, academically establishing the position that the Sharia, the common law, is the offspring of the Sharia. And examples are in the book, where there are a few examples. For example, the jury system was adopted from the Maliki view of Lafif, and then the offer and acceptance, etc., are all in the book itself. And from there, what happened is that the book tried to show that the common law and the Sharia were very consistent and congruent in the beginning, but then later on, it became it diverged. It diverged, and what the book intends to do is to show how can you make it congruent again. And in short, it's that at the current moment, with the current context of the legal framework, you have the common law, which allows a wider application of property rights. For example, the common law can accept riba contract as a valid contract. The Sharia can never accept a riba contract to be a valid contract. So what happens is that in order to apply the risk sharing, what we need to do is to put the Sharia to be, not to say consistent with in other words, to put the Sharia to be consistent with the common law in order for it to be enforceable in a court which operates common law. So there are some cases that were discussed in the book where we have to identify the perimeter of the Sharia in the contract itself in order for it to be applied in the common law courts. And that can be done, and it has been done. Even currently we have that as well. Not to put two governing laws in the contract, to say that, because from the UK perspective, Sharia law is not considered as a national law. So taking that into consideration and how do we draft the contract is all being discussed in the third chapter, where the second chapter is on the common law. The third chapter is with regards to how do you draft the contract, the Sharia investment contract itself. So there's a case study that was done, a hypothetical case where we were using a patent for a tube that is being used in a brain surgery, and that is how we established this multi-level of investment structure, and how you can just use one contract to facilitate this type of investment from the common law and the Sharia perspective. And that's the point on chapter 4, which talks about the building blocks, key considerations when drafting the agreements, the Sharia investment agreement template, and the application of that contract in this hypothetical case. Then after that is just policy recommendation and the conclusion. So yes, that's generally all about the book. I'm free to accept any questions. If there are no questions, then I'll probably ask some questions. Any questions about writing? If I can share, if you have, yeah.
Thank you for the presentation. I think I joined late, so I'm sorry. I didn't get the difference between bay and tijara. So can you please go over that?
I can't hear you.
The difference between bay and tijara.
The difference between al-bay' and tijara.
Yes.
Yeah, that's covered in the book. Al-bay' is what the book does is that it refines the meaning of al-bay'. Al-bay' can mean any exchange, mubadalah mal bil mal, any exchange of property rights. That's the definition of al-bay'. And there's different application of that definition. So in Baqarah, when people say that al-bay' is the same as riba, and then Allah did not say al-bay' is not the same as riba. Allah just said al-bay' is permissible and riba is prohibited. وَحَلَّ اللَّهُ الْبَيْءَ وَحَرَّمَ الرِّبَا. In that context, al-bay' includes all types of exchange of property rights, which includes even tijara. So tijara is like a subset of al-bay' in that surah. But in other surah, there are certain points where al-bay' and tijara are used in the same ayah. So it must mean different things. And one of the things that is mentioned that the book tries to not redefine but narrow down the scope of al-bay' is to define it as investment, because investment by itself is not mentioned in the Quran, and therefore it must be somewhere in the Quran. You can't just say that Allah overlooked investment, that's blasphemous. So it must be there, and therefore the refined definition of al-bay' in the book is that it means investment. And throughout the book, when al-bay' is used, it is to mean investment contracts. not tijara contracts. Tijara contracts is like your sale contract, your istisna, your lease agreement, your wakala agreement, your hiba agreement. All those agreements are considered as tijara contract, which is it gives you immediate profit. Al-bai' means that there needs time and the profit may come later, but there is the element of risk sharing in an al-bai' contract, whereby you share the risk of either making profit or making a loss, like an investment. I think, I recall reading back the book, and I saw, at page 25 onwards, as you can see that there is a table which does a comparison between al-bai' and tijara, from the definition, from the subject matter, from the property rights, from the risk sharing, from the tenure, from the profit rate, from the profit itself, from the loss perspective, trust factor, asymmetry information, to distinguish between al-bai' and tijara. Yes, Dr. Kinan.
Assalamualaikum, Dr. Anas. Thank you very much. Alhamdulillah, fine. Hope you are well. Okay.
I'm OKU.
By the way, my daughter got the same accident, almost the same accident you got it, so it should be fine, inshallah. Regarding the legal tool or the agreement, has any bank or institution adopted, or do you see any way that it can be applicable or in the application soon? And if not, so what are the challenges you face trying to make it applicable?
Good question. Personally, for myself, I tried to push it at the bank before, when I was in the bank, but I was not that successful, because most of the time the risk appetite of the bank is different. They are more comfortable with a debt-based product, which gives them a lower risk of non-performance or lower risk of default, right? And the enforceability, and when there is a default, they know that they can get this much immediately from the customer. But I have seen, not using my template, but I have also seen banks using risk sharing type of a product, where the bank joint ventures with the developer to develop housing development or a building, and thereafter they get 2 bites of the cherry of the pie, because after they've joint venture with the developer to finance the building of that building, they are also the end financier for customers who wants to buy that building. So I've seen it done before, but if I'm not mistaken, as I checked with the bank recently, out of 3 projects, 2 defaulted. One was okay. Other than that, I've not seen personally the usage of this, but I have seen that the queries with regards to risk sharing has increased. The wanting to understand risk sharing or develop a risk sharing product has also increased, but more on a very smaller scale, and they are trying to use it for more social kind of financing rather than corporate or retail financing. So that's I don't know, maybe Jack, have you seen any joint venture kind of a deal with banks? Syed Othman is a senior partner at Shumlin and Bob, my former boss.
This is Adam's payback line. Looking at the spot, sorry, thank you. No, I think the short answer is I don't think we've seen that many. But we, at the financial industry front, we are moving towards that. We have got several problems, as you know. We got the Basel treatment and stuff. So we want to do things, but accounting treatment pulls us down because of all the weightage and stuff. But short answer to the question is intention is there. Cumanya, I think it's a case of the mind is willing, but flesh or body is a little weak.
It's just the same as my injury lah. When I was running, I thought I could chase the ball, but my mind said I can go, but the body couldn't, so I fell and broke my collarbone.
Have you shared with everybody that the other opponent to the collarbone was actually the ground? Not moving ground. Sorry, since I have the floor, if I may,
Please.
just one comment, one question, if I may. I think just first a comment. I'm actually very proud to be sitting here, standing here. Sorry, I'm very proud to be standing here to say that we had Syed Adam for a couple of years, and it is a proud moment, and that was why I was here, because in those years I actually had more sleep before he came than after he's come. Not so much from a worrying perspective, to the contrary. The 4 a.m. waking up, he continues like that after he joined us. So he had the knack of making all the senior partners look very bad, because we get up very late. So thank you, and we are very proud for that. The second point I wanted to make as a comment was that I'm also, and this is something which I will say to all of you, you probably may not have the privilege that I have. We had a very many hours of intellectual discourse. Yeah. So good for me and too bad for you guys. Right? Can I just move to my question? And I think this is relevant. Something which we both share. As lawyers, and the title is legal tool. As lawyers, I increasingly find myself crafting documents more and more, to the extent that we alter risk sharing, to the extent that we either displace the risk rather than share it, or we mutilate it so much that the concept of how the structure is actually no longer has got any semblance of risk sharing. Yeah? But we say that's okay because we have one trump card, which is mutual consent, and we say so long as the contract is agreed, it doesn't matter. It doesn't matter that it has mutilated the risk sharing to such an extent. I struggle with whether we are doing the right thing. Of course, I continue to do it because it pays the bills, but I struggle whether it's the right thing. I just wanted your views, Dr. Adam, whether you feel that we have reached a stage where we actually should be looking at what we draft and ask ourselves, are we doing the right thing, and are we mutilating the concept to an extent? Thank you.
Thank you, Ja. I think Ja is just trying to be humble, because if he recalls, most of the time when we were having that kind of discussion, is that at the end of the day, what we do is we tell the bank, this is the position, and the bank makes, as the client, they make the final call, right? And that's what I think what we do. We draft, but in most of our contracts where we are drafting products, agreements, it's more for debt-based products. And when it's debt-based products, the risk sharing is not even there to begin with. The risk sharing that what the book is talking about, the risk sharing, is that it's a position where the bank will not know how much are they going to get when they go for enforcement of the contract at the end of the day, if there is a default. But for a debt-based product, like for commodity murabaha, for a fact that you are entitled to the asset sale price less the ibrah that the bank is required to give for unearned profit. In fact, currently there's another issue that just cropped up, if I can share, is on the recognition of ta'wid post-judgment, where the courts allow for ta'wid up to 5% right now, and then the ta'wid guideline says post-judgment it should be IIMM rate. Therefore, you can get, if let's say it's at 3%, or now it's 2.34%, let's put it at 3%, then the difference between the two is considered as gharama, and thereby you have to give it to charity. But there comes a situation where the judgment debt is not based on the actual sale price of the financing facility, but it's based on the settlement sum. So once the money is into the bank's account, the bank is saying, but this amount is based on the settlement sum, which means I've already given a haircut of the profit, and it doesn't adversely affect the customer. So can I treat the ta'wid as more than the IIMM rate? So these are some operational issues, and why are they intending to do this? Is because they want to get what they deem to be what contractually is theirs to begin with, their sale price. So that's a debt-based, I would say it's a debt-based mentality, because you know that this is the amount that you can get from the customer. So when you go for default and enforce it, you want to get that particular amount. But in a risk sharing, that won't happen, because you must accept when there is a loss, and you can accept when there is profit. Another example of risk sharing, I think now, I was just having a discussion with some mates the other day, is on this GDP sukuk, where governments can issue GDP sukuks, and if the GDP is high, then you can get higher return, but if the GDP is low, then you don't have to pay that much. So that's a form of a risk sharing. But ultimately, when you draft that kind of product, even though you're saying that it's based on GDP, normally it's going to be, the contract is going to be a debt-based contract, whereby it's fixed to something. So that is where I think we as lawyers, we have to advise that if you're using an investment structure, you cannot be protecting yourself and getting that much guarantee than if you are doing a debt-based. And that's where the risk appetite of the bank differs, because they say that I'm not a welfare institution, I don't want to be risking the bank's profit with a very volatile kind of a return. Then it will be difficult for me to convince the credit committee or the board to allow for this kind of products. Hence, to come back to Dr. Kinan's point and to address Jal's point, risk sharing I see from where the bank is practicing it is more on welfare products, social products. They're using wakaf, or they're trying to use the zakat money to do this type of financing, etc., using this risk sharing kind of a product, but not as a retail or corporate clients at the moment. I think the risk is a bit too big for them to accept at this stage.
At the end of the day, you're just putting it, look, the Islamic bank is just another bank. They are more concerned. That's why you're facing the challenges.
Yes, Islamic bank is a bank.
And a bank,
is a bank.
A bank would behave like a bank.
A bank would behave like a bank. Yeah.
That's the biggest challenge.
Yeah.
A short answer to Kinan.
So in other words, you would see a better kind of a product for risk sharing in the crowdfunding platform. P2P, right? But because it's smaller risk, then people are willing to go ahead with it. In fact, if you look at investment account platform, which was supposed to be for investment link products, but ultimately the investment structure is that you can choose to invest, but the contract between the bank and the actual investee is still a debt-based contract. The full flow is up there. If you use a circuit board, the electricity you cannot turn on the plug. So there's that element, that pullback of wanting to have that base is always there. It's difficult to breach that. Yes, sir.
Assalamualaikum.
Salam.
Thank you for the presentation, dear Doctor. I got a question. You mentioned that one of the tools that could be utilized is that you could incorporate Sharia law provisions within the sample of the common law contract in a way that this contract becomes enforceable in any common law courts, and that is very efficient too. What do you think about, I just wonder whether or not these two could be utilized for the civil law contracts. Civil law contracts where, the jurisdictions were not a common law, but civil law is prevailed. And of course, it is understandable that English law contracts is widely utilized, but Islamic banks, Islamic finance exist in many other jurisdictions where the civil law contracts are effective.
If Dr. Zakir Naik is here, the brother is a very good question. But
Thank you.
I don't know the answer directly to that. In fact, I just wanted to clarify that even within the same jurisdictions under common law jurisdictions like in Malaysia and the UK, the emphasis of governing law is very critical when you have cross-border transaction. It's not to say that this contract immediately can be used for any cross-border transaction. When it comes to cross-border transaction, we have to really look at the governing law properly and to understand how do you operate the Sharia within that governing law. Like for Malaysia, it's easy because we can just say as long as it follows what SEC wants, then in fact what has been done in the past is that you create a Sharia compliance clause in the contract itself to contractually bind the parties to follow what SEC wants, what SEC says about Islamic finance. Because in Malaysia it's easy because you have the SEC setting the perimeter of Islamic finance in Malaysia. But the moment you do a cross-border, then you have to look at that particular jurisdiction's legal requirements. For example, in the UK, they don't recognize, in the Beximco case, they don't recognize Sharia as a national law. So they say if you want to adopt Sharia law, you mention whatever the requirements of Sharia law in the contract itself. So if you want to say that you want the voids gharar, then mention it contractually, bind it between the parties that the parties don't want any contract that has any element of gharar in it, right? So how you draft the contract depends on which governing law you intend to use. As for civil law, I understand, for example, in Kazakhstan, which adopts civil law.
I'm from Kazakhstan.
You're from
Yes.
Kazakhstan,
Yes.
yeah. So your AIFC, if I'm not mistaken, has done where for Islamic finance they use common law, but for your country uses civil law. But for Islamic finance, if I recall back this discussion, and when I went to Kazakhstan in 2017, I think the Islamic finance under AIFC adopts the common law because that's where Islamic finance is developed in the world. So for Islamic finance they use common law, but for other laws they use civil law, right? So and I'm not an I don't know, I'm not able to advise on civil law, but I'm quite sure that I think you can have a situation where it's cross-border transaction, you put it as parties agree between each other what are the parameters of the Sharia that you want to adopt in the contract, therefore making it a bilateral contract between the parties to follow the Sharia, rather than you leave it when there is a gap, you want to refer to the Sharia, then that's the issue. Which Sharia are you going to adopt?
Okay, thank you. Yes, yes. Just one clarification. AFC is offshore jurisdiction within the territory of the Republic of Kazakhstan, and all participants should follow the. Actually, there should be. All entities that have registered within the AFC, they follow the English law. But if, for instance, two national entities would like to have the Islamic finance contract, they have to follow national jurisdiction. I mean, national laws, because we have the civil law jurisdiction.
Civil law
So
jurisdiction.
this is quite complicated thing.
Yeah,
and
it is.
I think it is another PhD thesis.
It should be a legal PhD thesis actually,
Yeah, true,
between governing law, civil law jurisdiction and the common law jurisdiction.
Yes.
That's right. It's very complicated and complex. But I think throughout the years we have seen that there is a understanding between common law and civil law. For example, when a company is dissolved or wound up in the civil law, how the asset can cross over to a company in Malaysia in a common law jurisdiction, that you can use the transmission of laws, transmission of assets under our local Companies Act, for example. I think we advised that before for one of our, if you recall, how the transmission of laws between civil law and common law can occur. So it can work, but you need to put your legal mind and head to it to address the potential issues.
Okay, thank you, Doctor.
For example, in Malaysia, I recall in the past there was this case called the Tahan Steel, and also the Lim Kok Po case, where Justice Wahab Pattaya actually ruled that BBA is Sharia non-compliant, is invalid, because at that time there was no IBRA yet and there's no rebate, so the bank would whack the whole asset sale price. In contrast to a loan agreement where the moment you default, the interest stops for future interest. But for Islamic Finance, the bank whacks for the profit rate for the full tenure. So the judge said that this is zalim. So he said BBA is Sharia non-compliant. Then he went to appeal. At the Court of Appeal, the court ruled that the BBA is Sharia compliant, gives their justification on the basis that most of the banks said that they will undertake to give the rebate. So in other words, there's no cannibalism between conventional and Islamic banks. And in one of the judicial conference, Justice Wahab Pattaya actually apologized for his decision. I still recall, I was back in the judiciary back then. And the former Chief Justice, Tun Arifin, he said, don't apologize. Your judgment create that ripple effect which forced the industry to develop Islamic finance. Had it not been for your judgment, we won't have the Ta'wid guideline, we won't have the IBRA guideline, which forces the banks to give a rebate for unaccrued profit, and we won't have this development of Islamic finance. So that's just one. I think that is also mentioned in the book. There's a chapter, there's a paragraph on that conversation that I had.
Thank you. I think
Okay.
we're running
Running out of time. Okay, sorry. I didn't prepare a slide. I wanted to do it over the weekend, but then, well, didn't have the time to dictate to my wife to do the slides for me over the weekend. So I apologize for not having the slides. But then again, I'd like to present this book to INCEIF Library, and perhaps you can have a read. And also, I was informed there was the soft copy version of the book in the library. So if you want to get more details of the book, then I suggest that you have read to it. If you would like to purchase the book, I tried to ask the publisher for a discount coupon, but they did not reply. So alternatively, I think the author gets 30% discount. So if you would like to buy the book, you text me or WhatsApp me or email to me, and I will buy it for you at that discount rate. But I can't give you that discount coupon because I checked the email, it says for authors only. So I can't give it to you, or else there's a breach of this risk-sharing arrangement, which is against the whole book by itself. So I can buy it for you, and then I can sell it to you. But that way it's a more Sharia compliant way of utilizing that coupon. My handphone number is 019 22 444 60. Maybe you can get it from the organizers of this. And my email is adam@rdl.com.my.
Okay, thank you.
Thank you very much. Assalamu alaikum.
Just a minute. I invite Mr. Amir Abdurrahman from INCEIF Alumni to give a token of appreciation to Dr. Syed Adam Alhabshi on behalf of INCEIF University. Okay, I would like also to invite Prof. Datuk Dr. Syed Othman Alhabshi, one of the authors of the book, who is with us today, and Ms. Noor Azlina Zorla from INCEIF Knowledge Management Center for Photography Session. Please.
Nampak cahaya iman.
Okay, thank you. That concludes our fifth book and author series. Thank you again, Dr. Syed Adam Alhabshi, for the great presentation.